So we have an important update in a critical challenge against rifle and magazine bans in states. The Trump administration just stepped up and joined to argue that state bans on rifles and magazines are in fact unconstitutional. And now that challenge is heading for oral arguments. So let's break down what is happening in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that right now is to check out the free legal guide that we have available. Again, it's free to sign up. All you have to do is put in your email, and then we email you over a PDF. You know, it's not legal advice, but it does give you some free educational information to help you along to understand some of the critical self-defense considerations and other 2A issues. And then also you can check out my website, armscholar.com. Over there, we have the legal guide, channel merch, and a lot of other things that you can check out as well. As I mentioned in the intro, in this video, we have an update in a critical challenge against a state's ban on so-called assault weapons and then also their magazine restrictions. This case is out of the state of Illinois, and it deals with the Protection of Illinois Communities Act, also known as PICA, and the restrictions that were put in place in the state of Illinois. Recently, the Trump administration stepped up to file a brief in this case, arguing that rifle bans and magazine bans in states like Illinois do in fact violate the Second Amendment. And currently the state of Illinois has appealed these challenges and the ruling that we got in the lower court to the Seventh Circuit Court of Appeals. The state of Illinois is arguing that the Seventh Circuit should once again review this issue and reverse Judge McGlynn's pro-2A decision, which struck down the rifle and magazine ban in the state. The Trump administration's brief recently argued that Judge McGlynn got the decision correct and that it should stand, and that the Seventh Circuit should affirm what he said in the lower court. And now all of this is going to come to a head once again because the Seventh Circuit has set oral arguments for this case to take place in mid-September. We also recently received Illinois' response to the appeal and the DOJ statements in their amicus brief, and the state of Illinois continues to argue that PICA does not violate the Second Amendment, that it does not implicate the Second Amendment, and ultimately that the Seventh Circuit's prior rulings on this type of issue should stand, and ultimately Judge McGlynn's ruling should be reversed. Now, you might remember that originally in multiple cases, a district court issued preliminary injunctions that were intended to halt the enforcement of PICA. However, the state of Illinois appealed those preliminary injunctions to the Seventh Circuit, who ultimately upheld those bans, which then led multiple cases at that time to seek immediate Supreme Court intervention. But the Supreme Court denied review in all of those emergency Illinois cases. However, in that denial, you did have statements from Justice Thomas where he stated that if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to a second-class right. So although the Supreme Court denied review to those cases at the emergency intervention kind of process, Judge Thomas did send a warning to the Seventh Circuit. Now, while all of that was happening, the lower court judge, Judge McGlynn, decided to move those cases along to a final merits decision. And on review of the merits of the case, Judge McGlynn once again found that PICA is unconstitutional and must be struck down. Illinois then after that decided to appeal, of course, once again to the Seventh Circuit, arguing that Judge McGlynn's decision should be reversed and that he did not follow what the Seventh Circuit prior said in a case called Beavis. Now, like I mentioned, the Trump administration recently filed an amicus brief in support of the plaintiffs and the residents of the state of Illinois, arguing that Judge McGlynn actually got this right, he did the analysis correct, and that the Seventh Circuit's prior military use analysis is actually incorrect. Now, in this recent amicus brief, the United States government argues that 3 years ago, the Supreme Court issued a landmark decision meant to break a habit developed by some states of treating the Second Amendment as a second-class right, subject to an entirely different body of rules than the other constitutional rights. Regrettably, not every state got that message. Just a few months after Bruin, Illinois outlawed some of the most commonly used rifles and magazines in America via a so-called assault weapon ban. In doing so, Illinois violated the Supreme Court's clear directive that states cannot prohibit arms that are in common use by law-abiding citizens for lawful purposes. Now, after final judgment, there are 3 very good reasons why this court, the Seventh Circuit, should reverse course and affirm the district court's injunction. First, as explained below, key aspects of Beavis's analysis are wrong, even judged against the Supreme Court's Second Amendment case law that existed at the time. Second, multiple Supreme Court justices, including Justice Thomas, have since made it clear that they disagree with Beavis and other recent lower court opinions, and that the court is likely to grant certiorari in the next term or two to address the errors of these opinions. Third, after the court's decision in Bevis, the district court held a multi-day bench trial, heard significant evidence regarding this issue in the case, and made factual findings that show that the act violates the Second Amendment as applied to these rifles and these magazines that are in common use for lawful purposes. For all of these reasons, the Trump DOJ argues that the Seventh Circuit should affirm what the lower court said. So there you have the Trump DOJ saying not only are these rifles protected, but also other things like attachments, magazines, suppressors, and other types of accessories, that all of those are protected arms. Now, there's a lot more that they argue in their amicus brief, but that gives you a good idea of the strong two-way stance that the Trump administration took in their amicus brief in support of the plaintiffs. However, now the state of Illinois has filed their response to these arguments, and in the response, Illinois, of course, argues that all of that should be ignored and that the lower court's decision should be reversed, and that these are militaristic weapons, that they're used in military service, and therefore they're not protected. They argue that the evidence developed on remand shows that, as the court stated in the preliminary injunction review in the Bevis case, that the PICA issue is constitutional. Plaintiffs' contrary arguments are rooted in the belief that Bevis was wrong and that the district court's decision should be afforded deference. But they state that this court reviews legal conclusions de novo, and the district court made no clear factual finding for this court to review, let alone afford deference. Furthermore, there is no reason to modify or disturb Bevis, as would be required to accept plaintiffs' arguments in support of the affirmance of the lower court's decision. They argue that Bevis faithfully applied Supreme Court precedent, that it's consistent with the opinions of every other court of appeals to have addressed the constitutionality of these types of statutes, and that it aligns with the record and the evidence. Therefore, they argue that the district court's decision needs to be reversed, and that, again, the Seventh Circuit should rule and decide in alignment with what they prior said in the Bevis case. Now, like I mentioned, all of this is coming to a head, and it's going to head to oral arguments, and those have been set to take place on Monday, September 22nd. It's going to be interesting to see how the state of Illinois and the Seventh Circuit judges actually handle some of the arguments that were presented by the Trump administration in their amicus brief, and how are they going to address some of the things that happened at the lower court, or are they just going to defer to what they said prior on the preliminary injunction issue in that Bevis challenge? It's interesting because there was not a lot of mention of the amicus brief filed by the Trump DOJ in the response by Illinois, so it appears that their tactic right now is simply just to ignore it, and maybe they're hoping that the Seventh Circuit does not bring that up. Regardless, I will note that, of course, the Seventh Circuit's track record has not been good when it comes to the Second Amendment. They tend to rule against the Second Amendment, and it's kind of similar to the Ninth Circuit, where there's a lot of losses that happen at the circuit court level because of the lean that they have being more liberal and more anti-Second Amendment. However, I will state that this is one of those issues that will likely make its way back to the Supreme Court. However, of course, the Supreme Court recently denied review to a lot of critical rifle ban cases that were even on the final merits. However, I will say even Kavanaugh during those denials said that the time will come very soon, maybe in the next term or two, where they are going to address these type of rifle bans and magazine bans. So if the Seventh Circuit continues to defy the Supreme Court and they don't take the Trump DOJ stance serious, this could be one of those challenges that the Supreme Court is actually eyeing, that they will take, because they mentioned that they are interested and will take one of these rifle bans or magazine bans in a term or two. Whether or not that's actually true, it's yet to be seen, but that is what they had stated when they denied the prior cases. So that's what's currently going on in the critical Illinois PICA challenge dealing with rifle bans and magazine bans. This is huge for other states, and there's a lot of other state challenges that are making their way through the process. Right now, the Duncan magazine ban is seeking Supreme Court review as well, so that's going to be interesting to see how that plays out. But again, that's what's currently going on. As we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, like I mentioned, you can check out the free legal guide that we have available for you guys. Like I mentioned, all you have to do is put in your email and we send you the PDF for free. And then we do some follow-up, free educational emails as well. And then just check out the website, armscholar.com, where we have a lot of things available for you along with the free legal guide. But as always, thank you guys for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.